Have done roll call and have a quorum. What are your wishes with the minutes of the June 30th meeting? The minutes were in the packet.
I'll make a first motion to approve.
It's moved by Harris to approve the minutes. Is there a second?
Second.
Second by Mike. Any discussion, corrections, questions? If not, all those in favor of approval of the minutes will signify by saying aye. Opposed, no. Then motion carries. And then we'll move on to the updates on the community policing survey. And Eric promised or indicated he would try to get us an update on the survey, but we were running a little over 1,000 surveys returned earlier, or as of, I think, last Friday. And then I realized when I got here that I don't have my internet access. So it was about 55, I think, in writing, 45% in electronic. And we'd like to encourage anybody in the audience or the viewing audience that would like to complete the survey to go to the city's website and look for the policing survey or contact the members of the task force, and we can get you the link. But please fill that out. It's important for us to have that information. So I think we're going to, he was indicating that he was going to begin the analysis of the results next week when he had a few more in, so rather than start and stop. But I think over 1,000 is probably a good baseline to develop trends and an understanding. Again, the purpose of the survey is to get the community's input on what their perceptions of policing are and priorities and how we're doing, and it will serve as a baseline for future surveys should the city decide to continue. So with that, we're very honored tonight to have representatives from the district attorney's office who would like to share their views on how their office operates and opportunities for improvement, and we look forward to it. And Teresa, I'm going to turn it over to you to introduce your team, and we're, again, very appreciative of the fact that you're joining us on a Wednesday night in downtown Wausau, 2 blocks from where you want to be.
Thank you. I appreciate the opportunity to be here. As we go along, I will be introducing some of the folks behind me here and their different roles within our office and different expertise that they bring. For those of you who I have not met, my name is Teresa Whetstone. I'm the district attorney in Marathon County.
And do you know our?
I think I know most, but I don't know have I met you before?
Oh, we've met.
Have we met? Okay,
Yeah,
I'm sorry. I should
I
never ask that.
right, no, not in that way. I used to work in probation parole. And
Yes.
So
Okay.
I was back in. So you and I worked on a couple domestic violence cases.
Okay, great. So, favorable history. Okay. Yay. So I was elected in 2016. Since 2002 as a prosecutor and the deputy district attorney with the office, I think, since 2006. And primarily I prosecuted sexual assaults, worked with homicides, but then also I did juvenile cases for quite some time. I have done all different types of cases within the office. So it's wonderful to have this perspective as a district attorney because I have seen a tremendous amount of change within the office and within the criminal justice system and within policing during that time. So I really appreciate the invitation to be here. I hope that we can address all of the questions that you may have. For those questions that we can't answer tonight, we will do everything in our power to get an answer to you. I want to encourage you to ask questions even during the presentation. If you're like me and you hold it till the end, you might forget what your question was. But hopefully we'll touch on a lot of the areas that you're interested in during the presentation. So if you want to hold your questions to the end, that's fine as well. A tremendous amount of this presentation was put together by Ruth Heinzel, if you want to wave. She's our diversion coordinator at the district attorney's office. You've been with our office for 6 years, and much of what she put together here tonight is outside the scope of her work as a diversion coordinator, but as you will see from the presentation, hopefully tonight, you'll understand that it is our role in the district attorney's office, just like it is the role of everyone in the criminal justice system, to be working towards having the most efficient and effective system possible. And whatever we can do to do that, whenever we see the need, we're going to go outside of the box, and we're going to do that. So I really appreciate what Ruth has done. She's an asset to our office and to our county for sure. So where's the clicker? How do I click? Do you click? Okay, thanks. Okay. It's going to be hard to see. A little bit, every place is a little bit different, isn't it? So I think that many of you have heard presentations from me over time, maybe at the county board meetings. And I think that some of the discussions that have come from those presentations have been very beneficial. And one of the things I believe that was even part of a resolution at the Marathon County level was that it is imperative that each part of the system be sufficiently resourced and each part of the system work as effectively and collaboratively as possible in order for the whole system to work to achieve public safety and justice. So I think that I wanted to start with some basic things, and I hope that these aren't too basic for all of you, but I never want to assume that there is knowledge about how the system works. So I start with the different ways that the district attorney's office may receive information by which to charge an individual. So that can be through arrest, through criminal citation, through referral, and there is also, we have an investigator within the district attorney's office. Sometimes we receive citizens who walk in or call our office. It may be that they're not sure where to go, they're not sure which jurisdiction. We might start those investigations in our office, in the district attorney's office, and sometimes bring them to conclusion or work with law enforcement, and that's another, I guess, source. So these are the decision points of law enforcement about how something, if something comes to our office, because the other option is that law enforcement, when they have a contact with an individual, also could issue a warning or choose to not refer to our office. With arrest is a very small percentage of what occurs when law enforcement is having contact with individuals in this community. I think we'll have some more specific details or statistics on that later in the presentation, but that is a very small number. Criminal citation used to be more limited to certain circumstances, and we have definitely expanded that process. And I'm not sure how much the police department has talked to you all about that already, but criminal citation is law enforcement is having a contact with an individual that they have probable cause to believe committed a crime. There's an assessment that that crime is either not a high level of danger to the public, or there isn't any other need for an arrest at that point. So a citation is issued similar to what occurs in a traffic situation, although in this case it requires their appearance on that criminal charge later in court. So that we receive those citations. Also, referrals are made to our office, which are law enforcement concludes their investigation. There is nothing provided to that individual to say, come to court at this time. But that referral is sent as a report to the district attorney's office. We review to determine whether or not that individual, there's cause and whether it's justice to charge that individual. And then we send a summons for that individual. Our office issues that, mails it to that individual to come into court on a specific date and time. So those are part of the arrest process as well is that individual can remain in custody if it is a felony offense that requires that person to remain. And therefore, that case on arrest would come to our office very quickly for charging, usually the next business day. If there is an arrest where the individual is, there's an amount set at the jail at that point in time, this is pre-charging, and that individual can post that money, they may bond out, post the money, bond out, and then they appear at a later date, usually depending on the type of case, within a couple days or within a couple weeks. So just so you understand, we don't go out and look for cases. They come to us, and they come to us in a variety of different ways. I'm going to interject, I guess, a little bit here to say that we have been trying for the last, I think, 3 years, I talked about efficiencies, to get that information to the DA's office in a way where our systems interface. So you can imagine the amount of data that's inputted by the police department. You have victim information, you have their address, their phone number, their driver's license, you have the same for the offender. You could have multiple witnesses as part of the incident, officers, you name it. Unfortunately, with the vast majority of information that comes from law enforcement to our office, the interface that was expected has not occurred. So all of those reports, the vast majority, I should say, of reports, with some exceptions, we have to take and manually enter all that information into our computer system. And we have a person, a legal assistant, who spends basically 40 hours a week at least entering that information. I could spend a whole evening talking about that and the difficulties and the complexities when you have municipalities with law enforcement agencies who have varying budgets. They work within their budget. You know, you can't impose a system upon them that will transfer that information because they just don't have the money to afford it. So I don't want to give the impression it's not because law enforcement doesn't want to work with us. That's not it at all. But I want to say that the Wausau Police Department does provide the vast majority of the referrals to our office, and or any arrest, citation, and they have been wonderful to work with as far as trying to problem solve, trying to make within the confines of what we have the best possible for efficiency. And because anytime you're inputting data more than once, human error, it's concerning because what we input in our office, and that would be where the error would come because we're transcribing from what law enforcement has given us, that goes into eventually the person's permanent criminal history. So it's really important that we get that right. The arrest tracking number is what, 16 digits? Is that right, I think? So, you know, if we could get that to automatically fill and eliminate that human error, you know, we talked about things that maybe the criminal justice system, if we could find a way, that would be wonderful. But right now, we don't have a solution, and I'll tell you, the Wausau Police Department has been wonderful about trying to do the best we can with what we have, which is a lot of what we do.
So a question there, and this is both directed to you and to Ben. So we just went through the system upgrade for the police and sheriff's department. How is the integration? Is there any integration with your system? And when we did that upgrade, was there consultation with the DA's office on how that information would integrate?
Yeah. Well, I would say that nothing has changed by way of inputting information into our system because if you're talking about Superior, is that what you're talking about? Okay. I have heard since I looked back in my emails, and I keep every email, which if you talk to DAIT, they could tell you how much they dislike that, but I keep all my emails, and since 2018, I have been promised it's coming. It's coming. And I'm not saying that to
What-
say,
Is that a layer? What is it?
oh, the interface, I'm sorry, the
So-
interface of populating a majority of that information into our internal, and I should back up a little bit. So the DA's office works with a system called Protect. So we can pull data from Protect, which is what Ruth will talk about a little bit later. So the Protect system, it would interface what law enforcement is entering into their Superior system. Oh,
Nope, go ahead and finish.
oh, okay, into the Protect system. So our system is a state-run system. And we're talking about county IT. And it is not because people haven't been working on it or been trying. It's the Superior work group, I want to say, that keeps running into barriers. And despite the best efforts of CCIT and our DAIT, it hasn't worked. So I think they were testing, and then I haven't heard now from there.
So I support the law enforcement, and Superion is one of my softwares that I support. And I have been working very closely with Superion. I took over the position a year ago, a little over a year ago, and we were promised this DA Protect integration with Go Live back in 2018.
So who made the promise?
Superion. did.
Superior.
And it was, I believe it was even in our statement of work. Don't quote me on that, but I believe that might be in our statement of work. We have been promised, now we did just do an upgrade today only because we are almost 2 years behind in an upgrade, so I pushed to get that upgrade done today. We were promised this DA Protect to work as of this build today. However, we have ran into more problems with Superion and how they have written this interface to pull in the data. We're close, unfortunately not close enough that they have to go back to the drawing board now and kind of revamp what it is that they want, what it is that we need to pull out for DA Protect so that this interface can happen.
And it's not a novel concept, the
No, it isn't.
interface
I mean, it's-
with Protect.
It's
And-
a fairly simple interface, and, you know, I bang my head against the wall every time, you know, we have these conversations when it's like, I know it's very easy what you need to do, but unfortunately, the way that Superion was programmed and how we, in IT, when we went live with Superion, how we built some of our modules in Superion, it pulls in the incorrect data that is needed for DA Protect. So that is where we're kind of now backpedaling and trying to still get this working with them.
And I would say, back to your question, I'm going to call you Supervisor Robinson all the time, back to that question, there was not, in my opinion, enough consultation when that process started.
I agree.
And I think that we are sort of the forgotten office in the criminal justice system oftentimes. And that is why I'm really, the chief did not pay me off to say these things. I really believe that the Wausau Police Department is exceptional in not forgetting about the district attorney's office. Because in order for us to function well, we need to function well together in our information sharing and have that be as efficient and error-free as possible. And they consult with us regularly and try to work with us. And I think that over the years, they have learned that that's their benefit as well. So, but yes, that is a problem. And we actually received some resistance when we tried to get involved in that process when Superior was being developed. So, anyway, boy, I have gotten to
Can I
slide
jump
number
in
2.
with a quick question?
Yes.
Going back to some of the basics that we may or may not understand, I just was wondering about, and Chief Bliven might need to jump in on this, but when you get a referral, that's not from a single investigating officer who checked on an incident. that comes kind of with the department's blessing. Within the department, an officer provides the initial draft of a referral to the DA's office to somebody, and then that comes over. How does that happen, Chief?
The referral process is really similar to a criminal arrest or a criminal summons. So, you know, an officer in any of those scenarios is going to respond to a complaint from a citizen in the community, or they witnessed something happen, and they begin an investigation, and they do their investigation, they document it in a report, whether it's a citation, a criminal citation, or a criminal referral, or a criminal arrest. And, you know, that routing process is, the officer does the report, the investigation. They might consult with a supervisor or detective when necessary, depending on the complexity of the case. And then that report then gets forwarded on to our lieutenant, our supervisor, who reviews the document to make sure that all of the appropriate information is in the report, the investigation is complete to the supervisor's approval, and that report then gets routed to the district attorney. So that's the process, but really that's the process for a custodial arrest, where we take somebody to jail, or whether it's a criminal citation or a criminal referral.
So when the DA's office gets it, they know that it's been vetted and it's not a wild card thing that somebody just thought was a good idea.
Yes, that's correct. Yeah.
Okay.
Yep, I believe that. I mean, that doesn't mean that they always agree with our assessment that probable cause exists for
That was
a
the
criminal
rest of my
charge, but-
question.
Yeah, but, yeah, the DA can answer that part of the question.
Yeah. So then, Ms. Whetstone, if you get the referral and the police department may say this, we recommend or ask that this individual be charged with these 4 violations, you sort that out and decide, you know, this one should be changed a level, this one we can't make a case for. How does that work?
Yes, that's absolutely correct. So our evaluation is independent. We obviously use the referral from law enforcement, what charges are specifically referred, as sort of a framework by which we look at what to charge, but then oftentimes we may charge things that are not listed, or we may charge different sections of the law that are referred. So it's just a framework. It doesn't dictate what we end up charging. When an individual is arrested, the charging, well, I guess in all cases within our office, the referred charges remain the same in our Protect, our internal system. We do not in any way change those. So at any point in time, we can go back and look and see what was referred versus what we ended up charging at the DA's office. So that we were talking about in preparing for this presentation. I love the conversations that come out of preparing for something like this, but we've talked a lot about how we would like to have the resources to be able to look at, are there any trends that we see with what's being referred versus what we're charging? What are those trends? What do they signify, if anything? Is that additional training, or is it something on our office's end that we should be looking at? But it's difficult to be able to take the deep dive into that data. We obviously don't have a data person to do that other than Ruth, and I'm not going to ask her to do that. She'd have to clone herself. But I guess that is valuable information, and it's necessary for the criminal history. If you've ever heard of NCIC and the criminal histories that are out there, it's very important that we maintain that referred charge as is. We don't mess with that, and then we enter our own charges for what the DA charges. I hope that answers your question.
Yeah, so you don't have anybody who goes over things and at the end of the year contacts the police department and says, I don't know if you noticed, but every time you refer a charge for this specific thing, we don't do it, so don't, do something else, or you can't.
Not at that level as like an annual review. I don't know, Chief, if you do anything like that. No, I do think that continually throughout the year, if we're seeing a trend with a particular type of charge that's not, maybe not got sufficient probable cause, or there's an element missing or something that we see that repeatedly, we will reach out to law enforcement. The Wausau Police Department will say, look, we need some training on this. We're seeing this continually come over. But we don't have a data set where we can look at trends of where that's occurring. I would love that. I think that would be wonderful. So,
So is there any opportunity with the university?
yes, we have a
program?
whole section on that. So we'll talk about
Okay.
that at the end with the specifics on that, which is encouraging too.
So if I could just
Sure.
stop you there, because every day they generate, the jail generates that daily report of the intake, basically, of those people that have been arrested and presented to the jail. And so that's what they've been charged with by the police departments,
Right.
not by your department. 'Cause
Correct.
they're awaiting arraignment.
Correct.
So have you ever done a basically evaluation of inputs versus out, I guess that's the same question
Yep.
Pat's asking. Do we have any trends?
Yeah, we haven't been able to do that. It's not because we don't want to do that or we don't think that's valuable. We just haven't been able to. We did sit down at one point in time with that spreadsheet and tried, remember in our conference room? And it just, the other thing is that we're not data analysts. I think it's really dangerous to have entities evaluating data when they don't have the expertise to know what they're really looking at and to know what the deficiencies are in the data. But absolutely, I think that would be a valuable process.
So how many, just not to hold you to a number, but if you could estimate of those cases that come in, how many do you come up with new charges?
I
Or you have any idea?
I have no idea. I don't know if you, it's a lot, yeah. Yeah.
And what goes, so help me understand your thought process.
Well-
So it comes to you, what do you do? What criteria do you apply to that triaging?
One of the main, I would say, things, and maybe I should just have you guys introduce yourselves, because I keep looking back at you and have, why don't you guys come up and introduce yourselves, because you're going to provide information. That includes you, Nikki.
Good evening, my name's Kyle Mayo. I'm an assistant district attorney, Marathon County. I've been here about 8.5 years. I was doing the felony drug trafficking cases for the last several years, still the lead on that, and then taking some general cases as well.
My name is Ruth Heinzel. I'm the diversion coordinator, so I'll be talking about diversion stuff hopefully later. We're only on the second slide, so
I know.
this might be a 3-day thing.
Yeah,
Who knows?
there might be.
Hello, my name is Nikki Delatolis, and I am in pre-charge diversion. I work with Ruth in particular.
And very new to our office, and I didn't say, but I should also say she's been very valuable in getting our data together and has been, hit the ground running in our office, which is wonderful, so thank you so much. So we just had a conversation today, the chief and I, about criminal histories. So criminal histories are vital to our evaluation of a case in many ways. One is that it is our threshold for diversion. So when we look at low-level first-time offenders, we're looking at criminal histories. Our investigator within the district attorney's office, who is a retired Wausau police officer, who has been looking at criminal histories for his whole life with the Wausau Police Department, and now with us, he is very good at evaluating those and condensing those in a read. If you've ever looked at a criminal history, it's terrible to look through. He can sift through that. He has contacts to try to follow up with. We get many that are incomplete from many times Cook County. Illinois will get incomplete dispositions because if that end is not sealed off with what happened in that case, a conviction, a dismissal, or whatever it may be, and it doesn't get entered into the criminal history, it just hangs out there. So a person is arrested for manslaughter, and we don't know what happened. So he does his best to bring that all together. Many times we are getting the police reports at 10 in the morning and we must make a charging decision by 12 o'clock, 12:30 at the latest. And we do, in many serious cases, and that's been a recent development, do probable cause hearings where we state to the court, we have probable cause to believe that this individual engaged in this crime, but we're not ready to charge yet. There are things we need to know that we don't know. And before we issue that charge, it's of such significance to the victim and to the offender that we want more time. So bail is set, and we do that in some of the more significant cases. But it is a rush in the morning to try to get these things charged. We thankfully have worked with CCIT and developed a way that we have this is only within the last year to 2 years, where we have a task, I guess I'll say a task list in our computer system that is observable to all in the office, where we can, if someone has time to charge, they go in there, they assign themselves to the case, then everybody else knows that person's working on the case, they don't duplicate work, we move on to the next one. So it's very efficient that way. So the criminal history is the threshold for diversion. It's also very insightful as to repeater status. So if an individual is a repeat sex offender, if they're a repeat domestic violence individual, if they're a repeat habitual criminal, meaning it enhances the penalty for that individual, repeat drug offender, that is something you have to look at the criminal history, or Wisconsin Circuit Court access at the very least and analyze it, because there are time frames in which those things need to occur in order for them to be valid for those enhancements. And so our attorneys look at that, and law enforcement does not. So that is pretty key. And so many people have out-of-state criminal histories. I think at one point in time, we were pretty solidly at a third of the individuals that we were running had out-of-state criminal histories. So that and Wisconsin Circuit Court access we look at, which anyone can look at, and we look to see if they have pending cases, if they're on a bond, or are they on a felony bond. They have provisions on the bond which say no contact with certain individuals, no contact with children, no drinking, all of those things we are looking at in our office before making that charging decision. Also, familiarity with the law, frankly. There are a lot of crimes that are, there are a lot of crimes. There are a lot of laws out there, frankly. And our office has seen from all different agencies every single day where a law enforcement officer who is doing the investigation just may not know. So there are many times also we don't charge what was referred by law enforcement. That can be because they meet the criteria, the individual meets the criteria for diversion, or we feel like it's not in the interest of justice for whatever reason to issue that charge. We have an ethical obligation, for example, if there is a search that is done in the case of the offender that is an illegal search and it's obvious to us that it's illegal, we have an ethical obligation to not issue that charge when we know, based on our legal analysis, that that's the case. So there are a lot of different variables, but I would say the number one would be criminal history, and number two would be just knowledge of the elements of the law and the different charges that are available.
I've got a lot of questions.
Okay.
That'll probably be at the end. This is fascinating. I've always thought, listening to you and your staff, I don't know how you guys even get close to doing your job with all the things that are in play. And I think we're on slide 2, and it's more evident than ever. Just listening to you, and I know you guys are working hard every day, and it's not an excuse. It's just, it's unbelievable. But real quick, just at the outset, so somebody, gets arrested. They're in jail. I mean, they made a huge mistake in their life. Maybe it was intentional, maybe it wasn't. But, they're sitting there, and the next day they're getting charged with a crime, and then they're maybe sitting in jail for a while. I mean, where is kind of outreach to that person? Who's responsible for that to help them understand, their rights, their process, what's going to happen? I mean, is there somebody that does that? Is that your office? Is that somebody else?
No, that's an excellent question, and please bring those questions, because I think there are a lot of misunderstandings about, or misconceptions about what happens in the criminal justice system. We are not allowed to talk with defendants. We cannot talk with them at all. So we work through their attorneys. And there is also, and I think Ruth can probably speak to this more than I can, but there's a social worker at the jail that also helps individuals with certain things, although legal analysis or what's happening with their crime, that's really up to their attorney. So if they qualify, well, the public defender's office will meet with that individual pretty quickly. Determination, it would be great to have a public defender present to you guys for education purposes, but that pretty quickly assess whether or not they qualify for a public defender, but they often will appear with the person even though they don't qualify necessarily, or it's unsure if they qualify. But if they don't qualify, they can get a county appointed attorney. So I don't know if you all know the difference between, yes, no? So if a person doesn't qualify for a public defender, which you can't have anything to qualify for by way of assets, or is very low threshold. But then if you went out and hired your own attorney, you'd have to come up with a retainer. And oftentimes people can't come up with that retainer, but they make too much for a public defender. So the court, first you have to go apply for the public defender. That's your number one. If you don't qualify and you want representation and you can't afford to go get your own attorney because of the retainer, then you apply to the court for an indigency hearing where the court assesses your finances and determines whether or not you meet the criteria for a county-appointed attorney. What that means is there is a group of, and it's a small group of private attorneys who take cases, defense attorneys who take cases of county appointments. And if the defendant shows that they qualify for that, then the judge will pick who that attorney is, and that person will then be appointed. As you can tell, that might take some time to get to that point. We also have a shortage of defense attorneys in this area. So if you qualify for a public defender, let's say that first step, you think, great, they're going to get the attorney right away. Well, there's often conflicts, ethical conflicts, that the public defender's office can't take the case. There might be other reasons that they could speak to as to why that public defender can't take that case. So then they need to assign someone else to take the case, and that can take a long time. So if they don't qualify for a county appointed attorney, then they have to either represent themselves or find a way to get their own attorney privately paid.
Real quick, so that happens between 8 and noon?
Well, only thing that happens between 8 and noon is they'll get a visit from the public defender's office to see if they qualify, and then a determination is made if that public defender may appear with that person at the initial appearance. That's all that happens between then and then. The rest happens all after the initial appearance.
Okay. But then the charges are made at
Yes.
noon every day, or?
Yes.
Okay, well.
Yes, so the individual oftentimes does not find out until right before court at 2 o'clock every day what they are charged with. So that's correct. Many other counties go through a system of probable cause hearings. We've evaluated that numerous times. And that's really somewhat up to the district attorney's office, but a lot of what happens in the criminal justice system is at the discretion of the judges. There are pros and cons to having, I talked about those probable cause hearings before we charge. Having that probable cause hearing and having the individual appear at a later date where they're officially charged. Some counties do that as kind of the rule and not the exception. And we've looked at that, and somewhat of because of how the system is structured right now, but also I don't know that that is the best way either. There are some major inefficiencies with that and delay, and there's considerations of victims' rights and notification to because if we do a probable cause hearing, the offender gets nothing. they don't get any information about what's being alleged or anything until the charges are issued. So there are a lot of pros and cons. Something we've looked at, though.
Okay,
All right.
I have a quick question,
Oh,
comment. And I'll keep it short because I know
No,
we need to
no.
get through the presentation.
We know
So
that, but-
one of the, and thank you, by the way, for all coming.
Sure.
One of the things I also kind of want to get out of this presentation is as you're going through and as you're telling us sort of things that are issues and, or
Mm-hmm.
challenges, if you could also kind of tell us, from your perspective, what would be maybe some solutions,
Absolutely.
recommendations that we could do, recommend or ways in which we can help you. And some of, obviously, the board members are also county board members as well. For instance, one of the things, going back a little bit, you had talked about sort of the challenges with the data system, with having an analyst, with Protect system. So I'm interested in hearing what your recommendations are. Would they be sort of to create a new position that needs to be funded by the county for just data analysts? Would they be to enforce contractual obligations in terms of Spirion? What do you assess as sort of solutions to some of these issues that you're mentioning?
Well, the Superion to fulfill what they said they were going to fulfill would be number one to me. I don't know how they get away with that, frankly. It's really not my place I'm not involved in the contract, but that would be number one because that is a tremendous, it's not just about the resource it takes in our office to input that data. It's about the possibility of error, and that's not acceptable.
Is
When-
that
Yep.
unique to Marathon County? Superion's used by, Marathon County and the city both use it.
Mm-hmm.
But do other counties and cities across Wisconsin use it? Do they have
You probably
a
know more than I
similar?
do.
Was that one of the reasons we,
Maybe Kristen knows better too. How many other?
Anago and Langlade Anago is the only other county or city in Wisconsin that uses the software that we use. Now, there's other like enterprise version, there's other versions that are used by other cities and other counties and other states, but we are the only one with Anago that use the, it's called the One Solution.
and we
version.
did that because? I asked that question because.
Unfortunately, I can't
because
answer
obviously-
that question because that was all before I hit, hit this position, so I'm not 100% certain why we went with that, if it was,
Well, it seemed like a good
cost.
idea at the time, right?
Yeah.
I mean, you put out an RFP and you make the best decision that you can, and
Right.
it was a group decision, and it was, the decision that we thought was the best at the time for our area. But we have had a lot of struggles with Superion. I mean, that's just a fact, in terms of being able to supply what it is that they promised to deliver. There's just no two ways about that. And I think Teresa's, statement that, they take 40 hours of work to input the records that have already been input into the system by law enforcement agencies is outrageous. I mean, the efficiency of that is just, in 2021, we should be able to do way better than that. And it costs the county and the state a lot of money to be able to, prosecute cases. And we shouldn't have to do that. But, we're working on it. That's all we can say at this point,
Unfortunately,
is
yeah.
we're working on
I
it.
mean-
So,
And-
for 2.5 years, because
And
we went go
I
live
hate
with.
saying that. I hate saying that we're working on it because I feel like we move forward
Yeah.
and then we get to testing and then they're like, oh yeah, well, we gotta go back to the drawing board because that's not how it was created. And
Yeah, go live for
unfortunately-
Superion was November of 2018.
Yes.
To give you some context of how long they've been trying to resolve that issue, so. And, the companies get bought and sold, and I think that's a piece of it, as well as, the version that we have, and you know this better than I do, is, that it's not gonna be supported, long-term. So, we're not gonna be able to maintain Superion for the next decade. We're probably gonna have to start looking at that relatively soon again and buying a new system, because Superion's not gonna be supported anymore because it's been bought and sold by another company again, so.
Well,
It's
Superion will
difficult.
be supported. It's just a matter of the version that we had selected.
Yeah, the
So,
system we
I
have
mean,
won't be supported.
Correct.
long-term, yeah.
So they will try and get us to go to a better supported system.
Which means they want us to spend more money.
Correct.
Right.
Yep. Oh, yeah. unfortunately.
And I guess I also want to say that even in the best case scenario, and correct me if I'm wrong, the input that now we're being told would be, or the information that would be interfaced would be arrest information. It would not be referrals or anything other than arrest. I think that's what we were told most recently, is that it's not going to cover.
So they can select what, they being the admin staff for the county and city, or, whoever's gonna be doing this, they can select which information gets sent to the DA's office, so they'll have a button to push, and whatever button they push on the arrest, it'll pull the arrest as well as the incident information around it. So that is gonna be manual yet, and then we'll load into DA Protect. I know that there was talk, and I'm not sure if that was part of Go Live either, was to have it automatically everything go to DA Protect. But as of right now, we're working on getting the arrest and the incident to flow together into the DA Protect system.
Yeah, so I'd heard that glitch rather recently, that because arrests make up a very small percentage of what we see in the criminal justice system, many are referrals. I want to say on average about 16% of what's coming to us is arrest. The rest is referral or citation. So if it only covers arrest, it's going to take care of 16% of our problems. So I hope that's not the case if we get it.
So these are intriguing details, but can I go out to like 40,000
Oh.
feet again?
Go wherever you want. This is for
Okay.
you. So.
Yeah, and to that point, the task force is charged with really looking at community perceptions around policing. And policing is kind of this tip of the spear. They bring a lot of the cases and arrests to you. But often people's perception of the criminal justice system is unfairly put on maybe your office, or, it's this whole group of really disparate entities. I mean, it's kind of astounding, all the different separate entities between state, the judges, the DA, the public. I mean, it's astounding to get through that process. And the person, whether they should or shouldn't be, and let's not forget about the victim and, actually the community that wants justice for people that commit crimes. I mean, that's all part of this too. There's a lot of interest in this, and your role is to prosecute people that commit crimes.
Right.
It's not to be this integrator of the community criminal justice system. You have a big piece in it. You have a responsibility. You get encumbered by other entities or processes or caseloads that are just unmanageable, that fit into that. So to me, it's almost like we need a criminal justice integrator person that really kind of shepherds all this, because that's not your job. It's not. I mean, it's not the judge's job and stuff like that. But so from a 40,000 foot view, I think, as we go through the presentation tonight, I really want to understand, how does the functioning of the DA's office impact, you think, generally, the reputation or the interaction or the perceptions that people have on policing, and the police's role in that too as well. So, to me, this law enforcement issue is interesting, the software, but I think we're getting a little into the weeds of where I would hope we would go. I don't know if that's.
Sure.
And I'm looking at you, but I'm looking at John.
That's fine. I'll be happy to move on. I do want to address, I think this is not related to the technology stuff, but the Criminal Justice Collaborating Council. It's a fairly new entity in our county. It's actually a new name for an old entity. So the evidence-based decision-making group is exactly what you just talked about, which is bringing together all the different stakeholders in Marathon County. It's been in existence for some time to try to coordinate, because you're exactly right. There are a lot of moving pieces. And what I've found really since I've been DA is how what we do affects other agencies or departments or roles within the criminal justice system, and we need everybody at the table to understand how, if I do this here, this is going to affect this here. And we're going to talk a little bit about that as it relates to some of the things that have happened over the pandemic, and some of the challenges, and how a decision at the jail can affect even though the individual is not there, a policy at the jail can affect how law enforcement does their job on the street, which can affect how our office, what we present to the judge and how it's received, and can affect whether or not the person is held in custody or how they're held accountable. And so definitely, they all work together. So we have the charging decision. We talked a little bit about the initial appearance. That can be as early as the next day after arrest, if they're arrested the night before a weekday, and they're still in custody, or it can be a bond out appearance, which is later. And the bond that's set at that point of arrest is not set by the DA's office. We have nothing to do with that. We're not consulted. That is set at the jail, what that bond might be. So when a person is first arrested, taken into custody, the DA's office has no input. We're not, well, I shouldn't say we don't have any input. Sometimes we get calls. We're on call 24/7 in our office. So we'll get a call from law enforcement requesting maybe additional information or input if the person maybe has a pending case where now they have violated the conditions of their bond, requesting input from the prosecutor, is this something maybe this person should be held? Is there additional information we should know about the pending case, safety, things like that. Other than that, it's set at the jail.
Can I ask a quick, on that, it's Mike.
Yeah.
So often, in my understanding, is that there's a local sort of culture about, for a disorderly conduct, this is the standard. Is that, in your opinion, present in Marathon County, or is it, is there sort of it's a DC, it's a, domestic violence, it's a whatever the charge coming in, is there sort of, don't want to say a written expectation, is there a cultural norm within the system that the jail staff uses? Or
Yes.
okay.
There's a bond book, actually, that
Okay.
guides them with criteria, many of the offenses, and that's really established through that bond book, which is not put out by the jail, it's put out by the state. So there is a bond book that guides them, yes. How they, I wouldn't begin to talk about how they make those decisions or what goes all into that. You'd have to ask them, but I just wanted to be clear that we're not involved at that stage of the system in determining bond.
So I was of the impression that the purpose of the bond was to either protect society from the danger of a repeat, to ensure attendance at arraignment or charging. So those decisions are made by the arresting officer and the jail, or
talk about that a little
where are those decisions? Maybe because the bond threshold ultimately impacts how long many people stay in jail. And if people don't have income, it disproportionately affects low-income people to the point where we have potentially higher numbers of people remaining because they can't come up with a cash bond.
I think we're conflating a couple of issues. So when an officer makes a custodial arrest and takes somebody to jail, it's their responsibility when they get to jail to make a decision on whether or not that person will be able to sign a signature bond immediately and leave the jail, or be held on a cash bond. And that's what the DA was referring to, is that it's in a bond book, it's set by the state, and we evaluate, are they from the community, are they likely to appear in court? And there's very specific written criteria that we follow, and we just basically check boxes, and if certain boxes are checked, then we assess a signature bond or a cash bond. If they're from the community, we think they're likely to appear in court based on the criteria, then we will allow them to leave jail on a signature bond after they're booked into jail. And then once the district attorney's involved, that's the next morning, the district attorney will then decide what charges are going to be issued, and then they will then make a bond argument to the judge the next day, and the judge then decides whether or not they're going to be released on a signature bond or a cash bond, how much that cash bond will be, et cetera. So we just make that initial decision based on very specific criteria that we don't control the night of the arrest or the day of the arrest. So when they're booked into jail, we give that initial assessment, but once the district attorney becomes involved with the charging, they appear in front of the judge, and the judge makes that decision and determination on bond. And bond conditions, for that matter, and whether or not they can drink, whether or not they can see the victim, whether or not they can have contact with children, all of those things that go into bond. We don't make any of those decisions at all. Is that helpful?
So if the person is arrested and bond is set and they can't make bond or post bond, they're brought to court the next day, the next business day, and the judge reviews that. So that initial setting of bond is very, very temporary, and then there's judicial review. The state argues for bond that the state deems it appropriate. Defense counsel argues for bond that defense counsel deems is appropriate. There's information brought to the court, and then the judge ultimately decides what the bond is that would be set. And we're going to go through actually the statute it's guided by the law. There's a criteria in the statute about how bond is determined. So this is just generally how cases progress. Felony cases are a little bit different than misdemeanor cases. Misdemeanor cases go from initial appearance to pretrial. If there is a negotiated plea, they would go there. Otherwise, they would go to trial and then sentencing. If it's a felony, the difference between a misdemeanor and felony is more than a year in jail or in custody. So if it's a felony, then it goes from initial appearance to preliminary hearing, which is the point in which the state is responsible to show by way of testimony or a hearing before the court that we have probable cause to believe that the defendant has committed a felony. And the court makes a determination. It's called bind over. And then after that stage, then we issue the official charging document, which is called the information. So if you've ever heard that terminology. The defendant can choose to waive their right to a preliminary hearing and agree that there is probable cause, or can choose to have that hearing. One of the, I think, things that we've done in Marathon County to save resources in the Wausau Police Department is that we have a designated testifier at those felony preliminary hearings, that first hearing stage, because the law in the state of Wisconsin is that hearsay is allowed at those. Hearsay is where someone tells someone else, that person who is told can provide the information. It doesn't have to come directly from the source. So because that's allowed, we have a designated preliminary hearing testifier, and we actually have a second that has come on board based on demand. What that does is that testifier testifies at all of those preliminary hearings that are held fairly quickly. I don't want to get into all the details of that, but fairly quickly after the initial appearance, because what was happening is, to your point, the individuals may not have an attorney. So there are time limits in which to have that preliminary hearing, within 10 days if they're on $500 or more cash, or 20 days if they're on less than that or a signature bond. And if that person is scheduled for a preliminary hearing, we in the past had to notice up a police officer to come in. And a lot of our referrals were coming in from night shift police officers who have families, who need sleep, who have lives. So they were coming in just to sit in the hallway and then wait their turn. There could be 20 hearings scheduled that morning. Wait their turn, and then we're bringing, these are people who are in custody, so we're bringing individuals over 3 at a time, then we have to bring them back, get new individuals. So all morning they could be waiting there when they should be sleeping, or they have childcare issues or whatever it may be. So we have a designated preliminary hearing testifier, retired Wausau police officer, and now a new individual added to that, who they testify at those hearings. They prepare for those hearings. We no longer need to notice up law enforcement officers. They testify from the criminal complaint, and that has saved, I don't know what our numbers were last year. Was it like $70,000 or $80,000 for the municipalities in law enforcement officer time and costs, because they don't have, many times that would be overtime, not to mention just how it affects them personally to do that. So that's been a great collaboration because the municipalities, including the Wausau Police Department, they pretty much consistently, we've been doing this for 3 years, they consistently have a percentage of cases that testifier is testifying on that agency's cases, and then we can divvy up the cost of that testifier to the agencies, and it is significantly less than they'd be paying if their officer was coming to testify. So that's a great collaboration that we've done, and it's very efficient. If the officer is not available, that's not a problem, because now we have our testifiers. So vacations and time off and days off, and we're not taking people off the road if they're on duty. So that's been wonderful. I think we haven't even made it off this slide. We keep going with this slide. So at the charging decision stage, the attorneys in our office, so will be, as of October 11th, I believe it is, 13 prosecutors in our office. The governor just approved another prosecutor, so we'll be able to hire. We are still five short, but we're very happy with that additional position, and we have a plan about how we'll use that position as efficiently as possible, which is great. But the prosecutors in our office are responsible to review the referrals, or however they come to our office, by arrest or citation, and determine whether or not that individual is appropriate for diversion. So that diversion I'm talking about right now is pre-charge. So before that person has charges issued against them. So we looked at that process within our office, and we said, this needs to be an inclusive process. This needs to be a process that is consistent across the board. So if you have different prosecutors with different levels of experience, you can have different decisions about diversion. We also were concerned about time to review the cases properly, because it's a big decision if you're deciding to take a case out of the formal criminal justice system, because there are a lot of safety valves within the criminal justice system that you're removing. So it's a public safety decision as well. So you want to make sure the person you have is truly a low-risk, low-level first-time offender. And then you have to consider victims' rights if there is a victim, obviously. So when we looked at that process, we have now streamlined the process, and we have the review. Remember I said our investigator does the criminal history review, so that now flags those individuals, those first-time offender individuals. So then if they are flagged for, it has to be a low-level offense, then they will be sent to one designated prosecutor who carries a full caseload as well, but is wonderful with diversion cases, and she reviews those cases for appropriateness for diversion. So it is taking away a lot of the concerns about inclusivity and consistency, and it's also streamlined that process. We have worked with the Wausau Police Department, and I know they've talked about the proxy. The point of diversion is to really give an opportunity for offenders to not have a criminal record, to meet their needs as a very early intervention if they're identified needs specific to that individual, and to reduce recidivism, maintain public safety, and then have a positive outcome if there's a victim, by way of maybe collection of restitution and accountability. So if, I lost my chain of thought because I saw you had a question. So you go ahead.
You used the word inclusivity a couple
Yep.
of times. What's the concern there, and how does that factor in? And
Yep, that's a great question. My concern, and my staff is a wonderful staff who I believe operates with great integrity and great intentions every day, but has varying levels of understanding of the purpose of diversion, the appropriateness of diversion, and the goals of diversion. And I don't want an opportunity for an offender to be placed in diversion being made on factors that are not the best analysis for that case and the outcome. So So when I say that, I mean, I don't want a prosecutor making a decision without having the fullest knowledge, I guess, of the diversion program and what it can do and the purpose of it, if that makes sense. So when you have people picking up charging, remember I told you we have this queue? Let's say somebody who specializes in a particular type of case is not available to charge. Let's say they're in court or in a trial, and then the person who would be the second choice for that is in court or in trial. You have somebody picking up that case to review who this might not be their wheelhouse. Maybe that's not what they normally look at by way of charging. They may miss an opportunity for that person to be included or be part of diversion. And we wanted to avoid that. So
you're trying to avoid having somebody there who never approves somebody for diversion who's involved in, say, domestic abuse or certain offenses, to maybe make sure that it's eyes wide open and, okay.
yeah, absolutely. And I think that people aren't intentionally, I've never gotten this sense from my staff that they just don't think of it. I mean, there's so much stuff going on in any given day, and sometimes they forget about the possibility of diversion. Sometimes they're rushed. Sometimes it's not what they normally do. That's not a good reason to not have somebody consider for diversion. So we really wanted to streamline that process. Part of that is working with law enforcement to ensure that individuals who are arrested really need to be arrested for all the reasons that we were talking about earlier. And historically, there was I guess the fallback was to arrest. And there were many reasons for that, I believe. I can't say for certain what those reasons were, but, and some of the individuals who were being arrested maybe didn't need to be arrested. But if they are arrested unnecessarily, and now we're considering them for diversion, some of the harm has already been done. Some of the good that we're trying to accomplish with diversion has already been undercut by the fact that they have an arrest record. So in working with law enforcement and having individuals cited in to appear, we talked about that process where they receive a citation to appear and there's not an arrest. First of all, that gives our office more time to vet that case for diversion, and it also eliminates that arrest record for that individual. If we determine that they're appropriate for diversion, then if they're successful in that diversion program, they wouldn't have an arrest record. And I don't want to steal Ruth's thunder because she's going to talk a lot about that. But I think that's very important, and the Wausau Police Department has been wonderful in discussing that process and working with us and saying, yeah, why aren't we doing that? We should be doing that. And so we changed that process, 2 years ago? 3 years ago? Can't remember. 2 to 3 years ago? So, so it achieves the goal of diversion, and it also, in the long run, I think limits some of the trauma that can be caused to a first-time low-level offender by being arrested.
It also preserves the incentive for the offender, or the alleged offender. If you've already arrested them, they well, screw it, it's already on my record. But if you can tell them, we can avoid the arrest record if you qualify for this, so talk to us.
Right.
Okay.
And it's very difficult to get an arrest. You can get an arrest removed from your record if there's a diversion, but it's difficult. So that process is really important, and I think our continued look at that, again, talking about what a resource Ruth and Nikki are to this county, they are continually looking at their program to see, is it working the way it's supposed to? Operating after revocation offenses are another prime example that the county was gracious enough to allow a conversion of one of our legal assistants to a paralegal. That paralegal vets the operating after revocation cases to determine if that individual if there's a possibility of getting validly licensed within a reasonable amount of time, usually that's about 9 months, looks at the driving record, and then can pull out those cases to get them in the diversion program and work with those individuals to try to get them relicensed, pre-charge. So that is also critically important. Just so you're aware, operating after revocation, there's a lot of talk about Why are we continuing to prosecute those? I just want to nip that right in the bud. Operating after revocation, in order for that to be charged, in order to be probable cause for that, it's based on the fact that the person had an operating while intoxicated offense conviction and their license was revoked. It's not because they had speeding tickets or parking tickets or anything, so they haven't complied with their driver's safety plan, which includes an alcohol drug assessment can be run reason. They haven't done what they need to do to get their license reinstated after an operating while intoxicated. So it's a public safety concern why that individual hasn't gotten licensed. Now, one of the things that we're going to talk about later is what, apparently much later, is what we can do to, if there is a monetary concern that they haven't been able to pay, and that's why they haven't gotten relicensed, is there something we can do with that? And we can also talk about undocumented persons who are not able to get licensed. So they can, if there was an operating while intoxicated conviction, the individual doesn't have a license, cannot get a valid license, but they create an imaginary license, and they revoke the imaginary license. And then if that person is caught driving, after that point, there can be a referral for operating after revocation, and the person cannot become validly licensed. So that's just, I guess, information. Again, we could spend a whole evening on that. So if there is selection of an individual as appropriate for pre-charge diversion, there is a justice systems assessment. I'll let Ruth talk about that later. And there's also, obviously, compliance with victims' rights. You've probably heard of Marcy's Law. We have some very important and strict obligations by way of victims for consultation before we make system decisions like this. One of the other things that happens before 12 o'clock is there must be, if there is a victim involved in a case, the person's in custody, there must be an attempt by us at least for victim notification. Especially in sensitive crimes, and we must generate, it's actually become a very thick packet of information for victims that we send out right at the charging stage, and they can return information to be involved with the criminal justice process, whatever is appropriate for that particular individual, whatever they choose. And so we have a staff of 4 victim witness persons in our office who work with victims of crime to make sure that their rights are honored and they have all the information that they need. But that starts at the charging phase. Actually, it starts now before the charging phase with law enforcement. It starts at the point of victimization, but for our office, it starts at the charging phase. There's also a post-charge diversion program for offenders. Again, I'll let Ruth describe that, but offenders who are a little bit higher level, who maybe don't need to be, in the interest of justice, convicted of a felony, let's say. We can work with a post-charge diversion that would have the person maybe convicted of misdemeanor offenses. There's all kinds of very creative things that we do. Convicted of misdemeanor offenses, placed on probation on those misdemeanors, and be on a deferred entry of judgment on the felony where they're not convicted. And if they successfully complete the terms of the deferred entry of judgment, which may be different than probation, maybe a little bit more individualized than probation in some ways, and then that felony may be either amended or dismissed. So that's a wonderful alternative we have in Marathon County, and it's not found everywhere, and neither is diversion. We have the second, if not the largest, diversion program in the state, and I believe our numbers right now are higher than Milwaukee by sheer number. So we are diverting and diverting and diverting because we feel confident in our process, we feel confident in the results, and I think it's a positive thing for the residents of this county. So, so Ruth is going to talk a little bit more. We're going to come back to these concepts, but the system of diversion is very individualized. It's a justice system assessment that is originally done. There's pretrial case management, there's some community service, day report, CMTS. I'm not even going to begin to describe all these things because Ruth can do that later. That's definitely her wheelhouse. And Laura talked about it, I guess. Lori already talked about it a little bit last time, so. So the duties of the district attorney, just to understand that it is our sole responsibility for prosecution of all criminal actions. And for those of you who have had the joy of listening to me speak, I get very passionate about issues related to the district attorney's office and criminal justice because I think it is so important to people's lives in this community as offenders and victims. So we also prosecute non-criminal actions, state forfeitures, county traffic. So we do not prosecute traffic that comes out of the city of Wausau as a traffic violation. That's in their municipal court. So if there's a municipal court, they're handling that. But for the county, we do that, and county ordinance violations. So I just wanted to give this visual, and some of you may have seen this before, but this is just sort of an idea of what flows into the district attorney's office. So when we talk about re-entering that data, I don't know how many administrative staff you have at the Wausau Police Department. 6. We have, 5 legal assistants and then an office manager and a paralegal. We have all of this information flowing from all these different police agencies into our office. We're solely responsible for dealing with all of them. So on top of this funnel is the different types of things that might come in from law enforcement. And one of the things that we're working on, and I honestly don't want to be pessimistic after Superior, because I know Superior probably isn't the norm, but we're reviewing, there's a request for information out, and maybe Chad's talked about this, from the county to have like a central report repository. So you see all these different agencies that send referrals to our office. These referrals come with all these, not in every case does it have every one of these, but a variety of different media, evidence, reports come into our office. Back in the day, literally a law enforcement officer would take the file and walk it over to our office and hand it to our secretary. And not that old, and that was happening when early days of our office, right? And so we would have everything in these police reports in this nice little folder and be handed to us. Now, we are going off, these different agencies all use different types of media. So we have to go either get the media ourselves from those agencies. So if you think about a shooting, how many different law enforcement officers respond to a shooting? Now they're all wearing body cams if they're from the sheriff's office, if they're from the Wausau Police Department. I just got an apologetic email from the chief at Everest Metro. They have now started to use body cams. And so they all get, and I say that because he understands what that means for our office to review. Body cams are wonderful. I have no problem with body cams whatsoever, but they all come into our office. So that's part of what we're working with law enforcement is there a way we can get back to the old days of compiling a case file? And the fear is with all these different places we have to look and grab information and all these different officers reporting that we're going to miss something. And I'm going to tell you that at every big case that I have ever been a part of, we get to right before trial, we're prepping witnesses and find out there's a recording that we missed. There's some kind of evidence that we were unaware of. There's a report that hasn't made it to us. And it's terrible. It is a gut-wrenching feeling to know that, first of all, that you could have gone through a trial and not known that, and the results would be catastrophic, or that you now have to go to the judge or the defense attorney and say, oops, we didn't know this, that we had this. And so if we could have a system where that all of that information from investigation can be compiled into a folder that we receive would be wonderful. But I fully understand what that's asking of law enforcement. as well. And we're talking about many different types of media. We're talking about a very large storage system. We're talking, it's a lot. So just to give you an idea of, discovery is the term that we use when we compile everything in an investigation that is required under the statute to be provided to the defense attorney. And so the digital discovery monthly estimates coming out of our office is 15,000 digital media files per month that we are responsible to review, know what's on them, and we're sending them to defense counsel. And digital media added is 365 cases per month. Paper discovery, 8,500 pages per month. So it's a massive volume. So we definitely need the collaboration with law enforcement to try to get a handle on that. And I understand the limitations of that as well. So just to give you an idea. This is the caseload of our office. I think this is just good background information for you guys to have. So the average caseload for our prosecutors, individual prosecutors, is 424 cases. This is well above the national standards. Obviously, 47% felony cases. We have 4,684 active cases in our office. So below the graph shows the average new cases per prosecutor per year that are coming in. So there's been a lot of talk about the backlog. And so understanding that these are cases coming in. So if the cases from the year before have not yet been resolved in a timely fashion, the cases coming in are piling onto the cases that are left from the year before. We're trying cases from 2017, 2018 right now. So these cases are coming in and they're piling up, and they're not moving through the system, and that causes a huge problem. Yeah.
Earlier, but how many new cases are every day?
I'd have to, I guess if you broke this down into, I don't know. I don't actually know.
Yeah.
Yeah, you know, the reason I think that's really difficult is because, and we could talk about this a little bit, but the arrest rate has gone down significantly. So we're receiving referrals in many different ways now. And it's hard to know. We used to be able to look at the jail list, and the jail list, if you remember, the jail list was like anywhere between upper 20s to 40 people on the jail list in the morning. And that has gone down, but now those haven't gone away. They're just being referred to us or cited in. So it's harder to compile or get a sense, I guess. So average days to, we talked about those referrals come into our office, and one of the places in the system where I think there can be delay or inefficiency is the amount of time our prosecutor takes to review the file and get it, something going with it for the victim's sake and the offender's sake, and judicial efficiency. We get these cases in on average, our best practice is 30 days. It used to be in the DA's office that cases were, I think you might remember, cases used to take 6 months to a year. We track if a case is not dealt with within 30 days. There is a system that is automatic in our office where there's a trigger where an email is sent, and you kind of get the warning, like this case has been sitting and it's been more than 30 days, what's going on? So there's a system in place, and then there's some accountability afterwards if that continues to occur. And we have been very good on our target. I want you to understand as well that when we talk about diversion cases, if an individual is referred and they're not charged and they fail diversion 6 months down the road, and then we end up charging that case, it looks like it took us 6 months to charge it, but in reality it was because it was in diversion. Or if we request for follow-up from law enforcement because we just don't have enough there, and then we end up charging it, it looks like it sat in our office for a certain amount of time. So that's actually figured into here. So the number might be a little bit higher than what it should be. So, we talked a little bit about this already. Our prosecutors are looking at probable cause, the number of charges, the severity of charges, victims' rights, and then considering for diversion or no prosecution. So one of the things that's really changed during the pandemic, and I guess I want to talk about this a little bit before I turn the floor over to Ruth, is we have a limited capacity in our jail. We've always had a limited capacity in our jail. I have this interesting newspaper in our office from 1991 when I was the Fun Days Queen in Marathon, where I grew up, and the bottom of the paper is that the jail is over capacity. And now I have next to it the paper of me as district attorney, newly elected, talking about the jail's over capacity. So it's been a long-standing problem. Now, what I will say to you is there are things that needed to be done and looked at within the jail population to ensure that our overcapacity wasn't a result of things that we could be doing better. And that's 100% true. There are not people being held in our jail pre-charge on operating after revocations, on possession of THCs. It's not happening unless they have missed court multiple times, or there's some other, they have 5 other cases pending, or I just want to be clear on that. And please look at the jail population anytime you would like. I think there's just a misconception out there about who's in our jail. The reality, and I really, if you want to chime in anytime, and if I say something wrong, what happened in COVID time, and is still not resolved, is that there was not capacity in the jail. So if an individual missed court and there was a warrant, that warrant then was not being confirmed when law enforcement had contact with that individual, because there was not going to be action taken on that warrant. So law enforcement was having contact with the individual on a warrant and saying, you have a warrant, we believe, have a nice day. That individual could be on probation and have an active violation of supervision or absconding and have a new crime and a warrant, and law enforcement was not able to confirm the warrant and was not communicating with Madison at probation and parole, because if they did, the response would be put that person on a hold. And so that affects then probation and parole's ability to institute revocations or sanctions or alternatives, because that person's not in custody. So the way they get alerted is routed through a report, and a person's not in custody. So then they have to go about this process when a person's out of custody, which you can attest to would be very, very difficult. Then the individual comes into court, if they ever come into court, and if we determine a cash bond is appropriate based on the criteria to try to get a cash bond at that point, the court is affected by law enforcement's decision not to arrest, which was determined by the lack of capacity in the jail to accommodate that person, not the other valid considerations that there might be. And that continues. I could talk for a really long time about that, but we have people, we ran it as of May of 2021 with 23 open cases at a time. One individual, 23 cases, 16 cases, 15 cases. We have 130 people with between 5 and 9 open cases at one time. Think about what that means. So they're out on bond and violating, and the frustration that law enforcement must feel, victims must feel, and it's just the fact that we have been cohesive with law enforcement through COVID speaks to our relationships, because nobody, I don't feel like we're sitting there pointing fingers at each other. It is the reality, but man, it's really a problem, and we cannot continue to function like this as a criminal justice system and be effective. So we are gradually opening up. However, like, if, for example, probation and parole has a limit of, I believe, 5 that they can take into the jail on holds. So what our probation and parole department, who's supervising thousands of people, has to pick the worst 5?
To give the committee an example, so I supervised high-risk offenders on probation and parole with Greg Agenbusher and some other folks under a program called Operation Progress. And I had my caseload, I was very, I will say, privileged. And Wisconsin probation parole as a whole, if you look statewide, if you look nationwide, probation parole, you cannot compare Wisconsin's versus any other states. The privileges we have as agents exceeds and has been challenged, as the attorneys in the room probably can attest to, in court over and over. We have rights and opportunities that no other state has. I probably, on an average day, personally, with a caseload of less than 50, had 10 to 15 people on investigative holds. And so now to sit here and hear this, now I was, my caseload was very small compared to colleagues who had 100 or so, and I was not a high-risk sex offender agent. Those 2 people were others, and we had 3 of us who were doing high-risk stuff at the time. And so it dramatically changes the system philosophy right now. And so, and it's not just on the county level. It impacts the local, it impacts the county, it impacts the DA's office, who's this like weird mix, right? It's state and county, and what foot is where on the sidewalk is awkward and affects the state folks, right? Because depending on the hold and the charge, sometimes it's a county hold, sometimes it's a state hold, and all this stuff. So I think I hear these COVID-related things. I also, though, I'm cautious, though, about, well, at some point the pandemic will be over. And so the task force philosophy was not necessarily pandemic related. I think it's something we have to take into consideration. I don't want us to continually get sucked into. I think it's great to hear. I get concerned that we're going to forget that COVID will end, I hope. I mean, we all hope. And that might bring us back. And I think it's a great time for us, though, to implement some changes when it comes back, to say, okay, where are we going to go from here? But to have 5 for that whole department, I would be done.
It's been very difficult, and I don't know if Ben wants to add anything on that, but I agree, and I really appreciate this opportunity to talk about all the things that are going on in the criminal justice system that have been in place pre-COVID, to look at what we're doing, who we're arresting. And if you think about all the things that we're already doing before the pandemic hits, that what I'm concerned about is that people look at the jail population going down and say, look what we could do because of COVID. And boy, the jail population's really down. So isn't that what we want? And isn't that great? And it's not great. And I am concerned that people make decisions without understanding what was already being done to reduce the jail population, who's actually was in custody in our jail, what the reasons were behind. Probation and parole is not putting people in custody for missing an office visit. It is not happening. So if that is out there, that is not happening. It is amazing what people can get through as far as being on probation and not being revoked, the violations that are coming through and not being revoked. So I just don't want the narrative to only be, wow, we've really seen what we can do with COVID situations. Now let's carry that through. Be very cautious about that. But I also think there has been a lot of good that's come out of COVID. Absolutely. We've looked at things differently and tried to do things differently, but it should not be the norm after the pandemic is over.
So
yep.
can I ask
Sure.
a question? One, are we safer or less safe today than we were at the start of COVID?
What's your definition?
Well, I think that's one of the problem is resources. And how do we apply them and the effectiveness of how we're applying resources. So at the end of the day, what metrics do you have? You threw out the 129 with 5 or 9 cases. But from the perspective of the citizen on the street, how has that affected the citizens' safety on the street?
Well, I can tell you, when you have someone who has an injunction and the offender is violating the injunction, and you call law enforcement and the jail won't take them, you ask that person how they feel. I got to say that, and I'm not saying, I'm not trying to say negative stuff about the jail. It's a capacity issue. It's not, I'm not trying to say that that's their issue. It's a capacity issue. But when we look at our programs in this county, we talk about drug court and we talk about cost savings, right? We talk about this person graduated drug court. There's some cost savings there. I'm just using this by way of analogy. So there's a lot of resources that go into getting that cost savings. And when you're taking people and there is a solution where they would not have the opportunity to commit further crime for our community. And we have chosen an alternative that puts them in a position where they have the opportunity to commit further crime. That comes at a cost as well. And a lot of times we focus on, boy, this alternative has helped this person, see how much money we saved. We're not looking at all the people who it has not worked for, and what is the cost to our community for those individuals. So if you have felony bail jumping, I'm really sorry, Ruth, I'm actually going to get to you in just a minute. So felony bail jumping is a good example. We were just looking at our felony bail jumping numbers. So if somebody's out on a felony bond and they commit a new offense, then they violated that court order, that bond, which is put in place, as we just talked about, for safety and protection and everything. So they get charged with a new crime, and they might get let out again and again and again and again, right? So we looked at our felony bail jumping numbers, and what do those mean? So when we compare ourselves, let's say, against the state of Wisconsin, the release rate of people in Marathon County from jail in 2016, pre-pandemic, everything I believe is what, 87%? Yeah, about 87%. I can't imagine what it's at right now. How many people there's a crime committed and they're not detained in custody. So what is our release rate compared to other counties? And how many people that are at a higher level of felony type offense, are out of custody on a bond and have the opportunity to commit more crimes? That's going to contribute to how many felony bail jumping charges that we have in this county. So we looked at, there's also a misconception out there that we're charging people for ticky-tack, I'll call ticky-tack violations of bond. I don't know what that be, because it's a court order and it's put in place for a lot of good, solid reasons, community protection. But so our projected for 2021 is 1,134 bail jumping charges for this year. Of those, it's projected that it would, for just solely a violation of the bond, not a new crime, 80. The rest would all be new crimes. That they're out on bond and they're committing a new crime while out on bond for another crime. So when people say to us, stop charging all those felony bail jumping, I'm the district attorney in this county responsible for public safety by way of determining charges, and this is not acceptable. So data can control a narrative, and you can use data in a lot of different ways. So if you have questions about the data that I present tonight, or you want more information, I'm happy to give it. But I just want you to understand that comparing like counties and what counties are doing, like the threshold for drug court is prison, for example. And that's the people that we're looking at. They're on the threshold of prison. If our threshold for prison in Marathon County is way over here, and the threshold in other counties is back here, and they're intervening at that earlier stage, we're dealing with a very different population in Marathon County than those other counties are dealing with. And that's going to influence what we need in our court, how successful it's going to be. And we have to look at that and say, what are our failings and why are we failing? Because you can't just say the threshold is prison when that definition is different in every county. So, oh, I could talk for a long time. You guys probably won't ever have me back. But, so Ruth, you have to go, don't you? Yeah, Kyle has to go sooner than Ruth. So, do you know?
Ruth,
how
what
we
did
can
you
get-
do wrong?
Do you know how we can get to his slide? Or- Okay, I'll let you do that. So Kyle is graciously agreed to be here to talk about drug trends, and I could talk about it, but definitely not at the level that he can. Just by way of introduction, we in the DA's office.
If you
work-
could go to the mic.
Oh, I'm sorry.
Because we're recording.
Oh, yes, we in the DA's office work very closely with law enforcement with regard to drug prosecutions and investigations. The DA's office, in all cases when there is a search warrant, with the exception of operating while intoxicated search warrants where there's a different mechanism, all other search warrants, and I believe last year there were 300 and some search warrants, we review every single one of them. And work with law enforcement and help ensure that there is sufficient probable cause, that there's sufficient reliability of the information, and that oftentimes, again, that's that 24/7 re-review. But we also work very closely with the Community Resource Unit and the Central Wisconsin Drug Task Force, and I'm going to have Kyle talk about that in the connection with the Wausau Police Department.
As I indicated earlier, I've been, for the last several years, was the lead drug trafficking prosecutor. So I would do the manufacture, delivery, possession with intent, convictions or charges for all types of substances that are going. Specifically with Wausau Police Department, we work with the Community Resource Unit very closely. I probably talk to them at least once a day, if not several times a day. They're calling me and talking about cases, what they're working on, individuals that we have that are already charged, that they have information on, search warrants, trying to get information on different investigations. And we work together very closely on the investigations. It's a much different aspect than a lot of other cases in our office, because we get that referral from law enforcement, and then we look at it and make our decisions. There aren't a lot of cases where we're involved in the decision of how to investigate, or what path should we go down, what should we do. And that's kind of the unique part of drug investigations, is we do work that way together of, hey, we're looking at this person for trafficking, what's our best way to go about it? Should we do a Facebook warrant? Should we do a cell phone tracking warrant where we're tracking them because we know they're going down to Chicago or Minneapolis to bring drugs back? And working on that, and I'm thinking about doing this. Is this okay? Are we on a legal ground that we can stop this car or do this dog sniff so that we can find different ways to do it? So the Community Resource Unit is awesome. I'm so happy they have it. They work on not just drug cases, but more nuisance properties as well. So it's, yeah.
Can I ask, is there a difference between the community resource and SIU?
Yes.
Okay.
So the Community Resource, and jump in if I get anything wrong, Community Resource Unit is just the Wausau Police Department.
Okay.
So it is 4 officers and a lieutenant that work within just the city of Wausau on stuff here. And I think the best way to describe it is they work on the more community level, where a citizen calls in and says, hey, this house next to me, there's traffic coming going all hours of the day, there's 30 people coming in and out, their cars are parking everywhere, my upstairs apartment reeks of marijuana, there's people hanging out that are leaving needles or leaving drug paraphernalia. They will then go and do an investigation into that house. It's a much more short-term investigation where they'll get their information, they'll go and do a search warrant at that house, and we'll deal with it. SIU, or now it's kind of morphed into the Central Wisconsin Narcotics Task Force. It's actually an FBI task force, so we have one of the local FBI agents is in charge of it, and and they're all federally deputized as well. That's made up of the Sheriff's Department, Everest Metro Police Department, Wausau Police Department, State Patrol, and Department of Criminal Investigations. So there are 2 officers from Wausau that are there. They focus more on the long-term investigations. They take a lot of their cases federally down to the U.S. Attorney's Office, and the big trafficking from Minnesota, from Chicago coming up. So I think it's similar, but it's different focuses. And we work with them just as much. I probably talk to them 10 times a day usually on their cases, and that's more too of talking about, okay, how do we go about this investigation? And we have this conspiracy with 15 different people in it. What can we do? What do we need to do? What do we need to prosecute it? And making sure that we have that. So I think they're both awesome entities. They're great. The people in them are great. They have different missions, and we need both of them. They're not being not used. They are busy every single day. They're busy. They're doing search warrants. They're seizing drugs. One of the things I think with kind of talking about the jail and people not going to jail during the pandemic is I think our numbers of possession cases you're going to see are going to go down, because when you're not, if someone has a warrant, you arrest them, you search them when they go to the jail. You find the heroin, the meth that they have on them. But when you're not taking that person to jail anymore, you're not finding those drugs. And individuals talk, the drug community talks. They know if they have a warrant, they're not going to jail. They know if they have the drugs on them, if they get stopped by law enforcement, they're probably not going to go to jail, they're not going to find it. So I think it's going to skew the numbers a little bit when we look at that of it's just not being found right now. It's not that they're not out there. The problem with meth and heroin is still out there. I think especially with the heroin, we see the overdoses have gone way up, especially in the city. The number of non-fatal overdoses is huge, and that's not coming the ones we don't know about. With the availability of Narcan, great to have it available, but we don't know about some of those. So you use heroin with your friend, you overdose, your friend has the Narcan, and they bring you back, and no one from law enforcement, medical, ever finds out about it. So I think we kind of just touched the surface of the heroin problem by looking at the number of overdoses that we have, because we don't know about all those other ones. Meth has grown exponentially. When I started doing the drug cases, so 2011, we had 17 possession of meth cases for the entire year in the entire county. Last year, we had 202. And this year, we're on pace, we're at 143. So meth is exploding. The one other nice indicator, not nice indicator, but good indicator of that is when we would find someone with a trafficking quantity of methamphetamine on them. It used to be if you had 10 grams of meth on you, we're like, oh wow, you have a lot of meth. That's a big amount. Now we're seeing people with 100, 150, 200 grams at a time. And it's not just one or two individuals, it's numerous individuals that are bringing that into the community. So I think those are kind of the trends. The meth has gone up exponentially, but we can't forget about the heroin either, and that's continuing to go up.
Kyle, just a quick question. In my head, I'm conceptualizing within your office, there's kind of like 3 buckets of potential drug crimes. There's the trafficker, the selling drugs. Maybe they use, maybe they don't. I don't know. The second is somebody that maybe is a criminal out of desperation, right? They're addicted. They're doing things because of the side effects or whatever. And then there's people that are caught and they're just a user. They're not selling it. They're not committing another crime. My assumption is that that group is probably pretty small in terms of your cases. But is that the right way to think about the 3 buckets, or is that, like, what percentage of these cases, does that split come out to?
Yeah, I think you have the for-profit drug dealers, I'll call them, the ones that aren't users, that are just selling to make a profit. I think those are probably the lowest level number-wise of drug traffickers. I think the biggest one is individuals that are using that middle deals or deal to then get the money to get their next use of the drugs as well. I think we've estimated probably 75 to 80% of the crime, overall crime, is somehow related to controlled substances. So it's not just the possession cases or the trafficking cases, it's you're stealing from a store because you want to go and pawn that to get money for drugs, or you're stealing from your family to get those drugs, or you're ripping off the drug dealer, or we had one robbing a bank in order to get the money to get methamphetamine. So I think it's a large, the drug user number is much larger than the trafficking, but that also spills into so many different areas in our office that it's hard to tell just going down, because it does affect everything. Operating while intoxicated, those are on the rise too, where you have individuals that are under the influence of heroin or meth that are out driving, and we're seeing those as well. So I think it's pretty much affects every area of our caseloads. Oh, yeah, guns is another problem. Guns and drugs go together. Because of the dangerous nature of drug dealing, they generally are going to carry some sort of protection. Generally, they're also felons, so then we have a felon in possession case that's going as well. We've seen recently in the last 3-4 years, the number of juveniles that are possessing guns has gone up and that are using those guns. There was one in the city where he was 17 or 18. He went with his younger sister to rip off a drug dealer that was 16, and the one individual ran after the other one and he shot at him. And luckily just grazed his head, luckily, but still injured him. So we're really seeing a lot of more violence coming from juveniles related to drugs and related to not just the hardcore meth, heroin, drugs, it's THC. That was a THC case. The baseball bat incident in Wausau that led to the drive-by shooting, that was over marijuana. Those were all juveniles that were going after another individual because of marijuana. So it's not just those heroin and meth cases that we're seeing the violence, it's also the marijuana cases that are becoming violent, and the younger and younger we're seeing. It's not uncommon for us to see 13, 14-year-olds on Facebook or Snapchat with guns, and having guns and displaying them and having no issue with playing with guns. So that's, I think, a big concern, not just for the citizen safety, for officer safety, for everyone's safety, having more of that brazenness regarding guns. Any other questions regarding that?
So can you, and I know this is always a sensitive subject, can you comment on, we're here talking sort of about race and law enforcement. Can you talk at all sort of about, is there some tendencies that you're seeing in the community in the charges? When I was an agent, manufacturing of meth was, white guys from Lincoln County, and things like that. Are you seeing, is there still some parallels of that within your department and what you're seeing coming through the court? Or has it become much more diverse sort of community of drug manufacturing, dealing, using, things like that?
I think it's a little bit of both. It's absolutely diverse. I have people from every race that are selling heroin, selling cocaine, selling methamphetamine. I think if you look at our general trafficking trends, methamphetamine is coming from California, the Twin Cities, and then coming over. The heroin is generally coming up from Chicago, Milwaukee area. The gangs down there are bringing that up here. But I don't know that it's necessarily one race that's doing it over another. It's everyone. It's really.
And are we seeing manufacturing still of meth going on in this community, or is that more coming in?
It's all coming in.
Okay.
Last time we had a meth lab, and generally now if we have a meth lab, it's like a 2-liter bottle of soda, kind of the 2-pot method. So it's a smaller, it's not a big, large scale lab. It's been probably over a year. It's all being made in China in a lab now, and just it's easier for them to bring it in that way and traffic it in that way. So we're not really seeing the manufacturing like we were for a while, where we were worried about buying the Sudafed and looking at all that. We still can find that, but it's generally being distributed in from the cities now. And they're bringing in a pound level quantities now from the cities. And that's multiple times a week they'll come in with a pound of methamphetamine that's then being distributed out. And I don't think it's just coming into Marathon County, we're kind of the hub, being on where we are with 29 and 39 coming in, and it's going out to Langley County, Lincoln County, Shawano, out Portage, all over. But I think we're still kind of that central hub of where it's coming into, central Wisconsin. Pound of meth, I am really bad at math because I'm a lawyer, but it's generally 0.05 to 0.1 gram per dose. So a pound is 425 grams, something like that. 454 grams. So if you do the math, I mean, it's a lot. 1 pound is a lot, and that's if it's not being cut down. So drug dealers will add substances to their drugs in order to stretch it out, and then they can sell that for more. So if they're buying a pound for $3,000, and then they can make that pound go further, that's how they're making their profit. Any other?
So how do we stop it?
That's the billion-dollar question. I think a lot, it has to go first on enforcement. We can't stop the enforcement, but we also have to look at the treatment side and figuring out why people are using. What is the underlying cause of the use, and treating that addiction in order to take that element away. Because they're not going to be bringing that amount in if it's not being used here. I mean, it's being brought in because that's what the market, the black market wants here, and that's not wants, but can support, and that's why that much is being brought in. So we have to look at the drug treatment and getting a better drug treatment system in place to get the addicts not wanting to use that and not wanting to buy that.
I do have a question. Why is there, in terms of looking at the drug trends, I mean, there is a dramatic increase from 2011 to 2020, even, obviously still higher for 2021. I'm guessing the higher rate because people at home, maybe during COVID, I don't know. But do you have an answer for why, there has been this increase over the last 10 years? That high from 17 to 202? Is it that the gangs didn't kind of exist here in terms of getting drugs here in terms of sort of how they funnel them, or?
I think that had a lot to do with it. I think especially the meth, making it in the lab and bringing it over is much easier for people to bring it in now. And I think over kind of throughout the state, that's kind of when, in the northern part, that's when the meth epidemic kind of started blowing up and getting larger. And it was, I think, easier to make, which makes it less expensive. And so more people are starting to use it because it's less expensive.
Do we know, is the second part of that method so addictive? Is the addictive characteristics of meth create more demand?
I'm sure, yes. I don't know the science of the brain with meth, but from trainings that I've been to, you can use meth once and get addicted to it.
Yeah.
And then you're hooked. It's a very addictive substance.
I know that before I retired, I worked in the DNR and in the remediation redevelopment program. We did the spill responses to the meth labs. And so but those numbers significantly decreased over time. Starting in about 2000, you saw a lot of farm-raised, rural meth labs, and you just didn't see them after 2015.
And I think that's just China's making it cheaper and less dangerous, because meth labs are extremely dangerous. It's very flammable, very explosive, and I think it's just now easier for the individuals to bring it in from the labs, and it's probably more potent. I mean, I guess talking about heroin, it's fentanyl is in there as well, and then you get all the different synthetic fentanyls that are out there that we're seeing, where it's 10, 20, 30 times more potent than fentanyl.
So when I was working and now when I teach about drugs and gangs, in the college level and stuff, I think central Wisconsin, the meth was a local thing. We did not have when meth started here, we didn't have the gang influence on it. Now it is a gang-driven thing. It was a gang-driven thing even then, but central Wisconsin and a lot of the Midwest towns, that was coming from a central local group. And I think in my experience looking back and what you look at the trends on the national level, now there's been a shift. And now it's a gang-driven thing. I think 20 years ago, I could identify 4 families and meth, and we would eliminate a whole bunch of it because it was local. It was a recipe. They knew it. They passed it around. If you were in the southwest part of the country or in urban areas, it was more gang-driven even then. It's just the cultural, how it influenced and stuff. So it's a different game today.
Absolutely.
Well, Kyle, thank you for coming. We're sorry you can't stay with us.
Absolutely, thank you.
I'm
for
sure
having
you
me.
are too.
Have a good night, everyone. Thank you.
I would petition for a 7th inning stretch at this point.
Can we take a 5-minute stretch?
That'd be fine.
All right, 5-minute recess.